In this lecture, we shall discuss the entry of appearance by a defendant after having been served with the writ of summons. Now, in the High Court of Ghana, when an action is commenced against a defendant and the defendant has been served with the writ of summons, in fact, on the face of the writ, you would even see the words that you are commanded to hereby enter appearance within 8 days after service of the writ of summons on you. And that if you fail to enter appearance within the 8 days, the court can actually proceed without further recourse to you and give judgment against you. In other words, if you fail to enter the appearance within 8 days, the case can actually go ahead and judgment to be entered against you. So it is important that a person enters appearance after having been served with the writ of summons. There are a few things we need to point out about the entry of appearance. The first point to note is that when the writ of summons is served on the defendant, and the defendant is a person who wishes to contest the suit, the defendant must enter appearance to the writ of summons. Now, what you must know is that the entry of appearance is not you having to physically appear before the court. No. It's a process that you will file, and I'll show you copies as you move along. It's not you physically appearing in the court. No, it's a process that you file, a document that you file before the court. The second point to note is that a defendant who fails to enter appearance stands the risk of having judgment in default of appearance being entered against the defendant. In other words, if you had to enter appearance and you didn't enter appearance, the plaintiff can proceed and obtain judgment in default of your appearance, and the court will grant them judgment. One key thing that you must note about appearance is that an appearance can be an unconditional appearance or it can be a conditional appearance. Appearance can be an unconditional appearance or it can be a conditional appearance. This one is a very critical fact that you can know. I have mentioned that an appearance need not be it's not your physical presence in the court. It's the document that you file. Now, that document that you file, the appearance, it can be either an unconditional appearance or it can be a conditional appearance, and I explain each of them. When the defendant enters an unconditional appearance, what the defendant is saying is that he is submitting to the jurisdiction of the court and indicating to the court that he, the defendant, is ready to participate in the action before the court, and then to put forward his defense. So if as a defendant I enter unconditional appearance, I'm telling the court that I have submitted to the jurisdiction of the court. I'm informing the court that having submitted, I'm ready to participate in the action. I'm ready to file my defense so that the case will be heard on the merits. That is what happens if a defendant enters unconditional appearance. It means he has no problem with the whole writ that you issued against him. He has no problem with the jurisdiction of the court. So he's ready to participate in the trial. Now, the reason we are explaining appearance is because if we take a critical look at a writ of summons, like I've said, you will see that there's a command over there that the defendant must enter appearance within 8 days, failing which judgments may be entered against the defendant. So unconditional appearance means that I am ready to contest the case on the merits. So I have mentioned that an appearance can be unconditional or it can be conditional. I have explained what the unconditional appearance is, that you are submitting to the court jurisdiction. You are indicating that you are ready to participate in the action and put forward your defense. As time goes on, I would explain what you mean by the conditional appearance. But for now, you know what the unconditional appearance means. Now, who may file appearance? Can a defendant who has been sued file appearance himself, or it must always be filed by a lawyer? The answer to this you will see under Order 9 Rule 1 of the CI 47. And it reads in this wise, I quote, subject to Order 5 Rule 1 of these rules, a defendant to an action may, whether or not the defendant is sued in a personal capacity, or as a trustee, or as a personal representative, or in any other representative capacity, has filed an appearance in the action and defend it in person or through a lawyer. It means that from Order 9 Rule 1, the defendants can either enter appearance and defend it in person or defend it through a lawyer. Why did Order 9 Rule 1 say it is subject to Order 5 Rule 1 of the CI 47? Because you remember when we got to Order 5, we're told that if a person is a person with disability, that person must always act through a next friend or guardian ad litem. Remember Order 5 Rule 1 Sub 3. It says that anything which in the ordinary conduct of any proceedings is required or authorized by these rules to be done by a party to the proceedings shall, if the party is a person with disability, be done by his or her next friend or guardian ad litem. Remember this. So even though Order 911 is saying that we may file the appearance in person or through a lawyer, there's an exception. Because if you're a person with disability, that's one, it must be done by your next friend or your guardian ad litem. In other words, the general rule is that an appearance can be entered by the defendant personally or by the defendant's lawyer. Now, the appearance that you are referring to, if it's a person with disability, that appearance can actually be entered into by the next friend or guardian ad litem. And the person with disability, you can't enter appearance yourself. It must be done by your next friend or guardian ad litem. And that person too must act by a lawyer. As I have mentioned already, if we talk about the method of filing the appearance is not physical presence in court. It is a process filed in the manner specified by the rules that an appearance has been entered by the defendant. So when you say enter appearance, we don't mean go and appear in the court and say that I'm here. No. It means that you must file the process before the courts. So take a look at Order 9 Rule 2 Sub Rule 2. It will let you know what the contents of an appearance, how it is supposed to be, and what is supposed to be in an appearance. So look at Order 9, Rule 1 Sub Rule 2. It gives us the content of the notice of appearance. It says that the residential and occupational address of the defendant shall be stated on the appearance, whether the defendant defers in person or through a lawyer, and whether this is stated in the writs or not. The residential and occupational address of the defendant shall be stated on the appearance, whether the defendant defers in person or through a lawyer, and whether this is stated on the writs or not. Order 911 Sub Rule 3. Where the defendant defaults in stating the defendant's residential and occupational address on the appearance form, the plaintiff may apply to the court on notice to compel the defendant to do so, and the cost involved shall be borne by the defendant. And where the defendant fails to comply with the court order within the stipulated time, the defendant shall be considered to have not entered appearance. So Order 9 is saying that you, the defendant, you must make sure that in entering appearance, you disclose your residential and occupational address, whether you are defending the action in person or through a lawyer. Even if this is not on the writ, you must still state it. And if you fail to state it, the plaintiff can apply to the court to compel the defendant to disclose it. And if you fail to disclose it, the court can actually make an order and consider that you have not entered appearance. Now look at Order 9 Rule 3, further on the content of the notice. It says that the notice of appearance shall be as in Form 5 in the schedule, and shall specify an address of service, which shall be A, the defendant's place of residence in the country, or if the defendant has no place of residence, the address of a place in the country at or to which documents for the defendant may be delivered. Or sent. And where the defendant appears through a lawyer, the business address of that lawyer in this country. Order 9 Rule 3 Sub Rule 2. A notice of appearance shall be dated on the day on which it is handed in at or sent by post to the registry, and shall be signed by the defendant if the defendant appears in person or through the lawyer of the defendant. Now, at this point, it may be necessary to take a look at a sample of a notice of appearance to see how it looks like. Now, take a look at the process we have on the screen. You will see that we have the title of the suit here. We have the suit number. We have plaintiff. We have defendant. We have the address of the plaintiff. We have the address of the defendant. Now, there's an appearance that the defendant is entering into through his lawyers. So you see, notice of entry of appearance under Order 9 Rule, under 9 of the CI 47. Look at how it's worded. Please take notice that the defendant herein has this day entered appearance with the plaintiff's writ of summons and statement of claim in above mentioned suits through his lawyers, Jack Toller Esquire, whose address for service, practicing license, or chambers registration license numbers appear hereunder. And then you see plot number 419B, Jubilee House, Liberation Road, dated at Toller and Associates, Accra, this 30th day of July 2019. Then the lawyer for the defendant signs, he gives his license number. The registrar of the High Court comes over here. Then this appearance, you must serve a copy on the plaintiffs. So you mentioned that, and for copy of service on the plaintiffs or their lawyers, then the Bakwes Swiss Law Offices house number, so that the bailiff will go and serve this appearance on this people over here. Now, for every appearance entered into by a lawyer, you must have a certificate over here. So every appearance entered into by a lawyer, this certificate will be here. I, so registrar of the court, certified that appearance of the plaintiff with of summons was entered into on behalf of the defendants herein. Then you have the sign over here, registrar, and everything comes over here. Now let's come back to the appearance. Look at the contents. We have over here the name of the lawyer entering the appearance. We also have the address of the lawyer where we'll serve, so that now if we want to serve the defendant with anything, we'll serve it on the lawyer on this address. We'll have the signature for the lawyer too, that will be over here. We have the license number over here. So these are things that you should bear in mind, so that when we get back and we are looking at the content of an appearance, it will now make sense to you. So have this at the back of your mind, and then let's go back. Now let's look at the content of the appearance as we've seen under Order 9 Rule 1 Sub Rule 3. Order 9 Rule 1 Sub Rule 2 says that you must state the residential and occupational address of the defendants. We saw it over there. We also mentioned that it shall specify an address for service. So we saw that the lawyer gave the lawyer, so where the defendant appears through a lawyer, the business address of that lawyer in this country. You saw that we had that one over there. So that is how the appearance is supposed to look like. What is the time limited for the defendant to enter appearance? Now, if you look at Order 9, Rule 5 of the CI 47, the rules indicate that in the case of a writ served in the country, the time limited for appearance would be 8 days after service of the writ, or where that time has been extended by the court within that time as extended. So in these rules, references to the time limited for appearance are references A, in the case of a writ served in the country, to 8 days after service of the writ, or where that time has been extended by the court within that time as extended. So if it's a writ that is served within the jurisdiction, once it is served on you, have 8 days to enter appearance. And in the case of a notice of a writ served outside the country, The time you have to enter appearance is the time limited by an order of the courts under Order 7 Rule 13 or 8 Rule 4, where that time has been extended or to the extended time. The reason we have Order 9 Rule 5B is that when you are granting leave to serve somebody out of the jurisdiction, usually the order that is saying that serve him out of the jurisdiction will specify how much time the defendant will have to enter appearance. So if you look at Order 8 Rule 4 of the CI 47, it says that an order granting leave to serve notice of a writ out of the jurisdiction shall provide a time limit within which the defendant to be served shall file appearance. An order granting leave to serve notice of a writ out of the jurisdiction shall provide a time limit within which the defendant to be served shall file appearance. It means that it's not absolute that you have 8 days wherever. If it's for service of a writ within the jurisdiction, 8 days. But if you're serving out of the jurisdiction, then the order granting leave will specify the time to enter the appearance. As I've mentioned already, an appearance can either be unconditional or it can be a conditional appearance. I had mentioned that if a defendant enters unconditional appearance, the defendant is acknowledging the court's jurisdiction, you are acknowledging the regularity of the writs, you are recognizing the regularity of the service of the writs. That is if a defendant enters unconditional appearance. What if the defendant enters conditional appearance? And from this one, I'll first explain it from what we have seen over here. That for unconditional, it means you are acknowledging the regularity of the writ, you are acknowledging the regularity of the service, and you are acknowledging the court jurisdiction. In other words, if you have a problem with any of these, if a defendant brings an action against you in the courts and you want to object to the court's jurisdiction, you have a problem with the regularity of the writ, you have a problem with the regularity of the service of the writ, then you don't enter unconditional appearance. You rather enter what we call conditional appearance. This is what the learned author of civil procedure in Ghana, S. Kwame Tete, in his book, Civil Procedure, A Practical Approach. This is what the learned author says at page 247. Now, when I read this, bear in mind what I have said earlier, that if you intend to object to the regularity, court jurisdiction, regularity of the service, or regularity of the writ, you can enter conditional appearance. Now, by the time I read out these words from Kwame Tete, it's supposed to make it clear to you the circumstances under which you can enter a conditional appearance. This is what the learned author says at page 247, and I quote, "An entry of conditional appearance reserves to the defendant the right to apply to set aside the writs. An entry of conditional appearance reserves to the defendant the right to apply to set aside the writs. Leave is not required for an entry of conditional appearance. A writ that substantially departs from the prescribed form, such as the omission of the date of issue, may be set aside under the rule." In Republic versus High Court Accra, ex parte Haiti, the Supreme Court reiterated the circumstances when conditional appearance may be entered as, and I quote, "We would like to reiterate that a conditional appearance is to enable the defendant who intends to object to the issue or service of the writ or notice of the writ on him, or to object to the jurisdiction of the courts, to apply to the court to set aside the writs or notice of the writs or service out of the jurisdiction." This is a very critical statement, and I'll read it again. In Republic versus High Court Accra, ex parte Haiti, the Supreme Court reiterated the circumstances when conditional appearance may be entered. So it means in this case, the Supreme Court has mentioned the circumstances under which you would like to enter conditional appearance. And I'm quoting, "We would like to reiterate that a conditional appearance is to enable the defendant who intends to object to the issue." So the first one is the issue. "Or intends to object to the service of the writs or notice of the writs on him." Let me make this one. "Or intend to object to the jurisdiction of the courts you can apply to the court to set aside the issuance of the writ, set aside the service of the writ, or to set aside to object to the jurisdiction of the court. That is when you enter conditional appearance. The learned author goes ahead to say as follows at page 247, and I quote: Before entering appearance or upon entering conditional appearance, the defendant may apply to the court to declare that the writ or notice of the writ has not been served on the defendant. The rule applies where personal service was not effected on the defendant. Where the writ or notice of it was served on the defendant in an irregular manner. Where the writ or the notice of it was served on the defendant in an irregular manner. The application under Order 9 Rule 8 of the CI 47. Again, upon entering conditional appearance, a defendant may apply to set aside service of the writs on the ground that the service was defective, as where the defendant asked to see the original writ, but the bailiff declined or substituted service was ordered when the defendant was out of the jurisdiction at the material time. A defendant who is also claiming diplomatic immunity may enter conditional appearance and apply to set aside the service of the writs. But if he enters the unconditional appearance, it will waive that immunity. Now, Kwame Peter goes ahead at page 248 as follows: that after entering the conditional appearance, what do you do? An application to set aside the writ or service or non-service, or to discharge leave for service out of the jurisdiction, ought to be made promptly, lest the conditional appearance crystallizes into an unconditional appearance after 14 days. Entry of unconditional appearance would constitute waiver of the objection, so would a step in the action by the defendant that compromised the objection. Now let me explain what is happening over here. Now, if you enter conditional appearance, it is just a document as well. Just one document like the appearance that we saw. Now, that is how a conditional appearance looks like. So if you have a problem with the writ of summons, you have a problem with the issuance of the writ or the service of the writ, what you do is to enter a conditional appearance. So they're like just like the appearance, the unconditional appearance. But over here, you have conditional over here. Or the 907 of the CI 47. Then you just have, please take notice that the defendant's hearing has this day entered conditional appearance to the plaintiff's writ of summons and statement of claim in the above mentioned suit through a lawyer's Dactola Esquire, whose address, practicing license appear hereunder. Then you give the address and the license. You sign here, address to the registrar, then you address it to the lawyer on the other side for him to be served. Then you add the certificate as well. So it's just like the normal appearance, except that with this one, you are just saying that you are entering conditional appearance. And remember, as we've been told in Ex parte Haec, you enter conditional appearance if you have a problem with the issuance of the writs, service of the writs, or service of the notice of the writs, or you intend to object to the jurisdiction of the courts. So now that we know this, when you enter the conditional appearance, what do you do next? You have the next 14 days to bring an application to now strike out the issuance of the writs, service of the writs, or to object to the court jurisdiction. So there are key things you must note before we proceed. It is that one, in the event that the defendant has any reason to challenge the regularity of the writ, you have any reason to challenge the service of the writ, or you have any reason to challenge the jurisdiction of the court, please, defendant, you must enter conditional appearance. We've seen how the conditional appearance looks like. It only gives notice to the plaintiff that the defendant intends to challenge the jurisdiction of the courts, or the defendant intends to challenge the regularity of the writs, or the defendant intends to challenge the service of the writs. In the event that the defendant does not raise the challenge timelessly, the defendant will be deemed to have waived that right to object. So if there's a problem with the issuance of the writs and you don't enter the conditional appearance, or after entering the conditional appearance, as you've been told, you have 14 days and you don't bring the application within the 14 days, you begin to have waived that right to object. The only one you can't waive is jurisdiction. That's one, even on appeal, you can raise it. But if you have a problem with the issuance of the writs, you have a problem with the service of the writs, please, if you enter the conditional appearance, you must object timelessly, i.e. within the next 14 days. But if you don't object within the 14 days, the conditional appearance will change to become a non-conditional appearance, and you will lose the right to now object to the regularity of the writs or the service of the writs. The only one that you cannot waive will be the jurisdiction. Now, whether you apply within the 14 days or not, you can raise at any time, even on appeal. If you look at this case of Amoasi III versus Twintor, Amoasi is Amoasi III versus Twintor is Twintoh. Amoasi Amoasi III versus Twintor Twintoh. Reported in 1987-88, One Ghana Law Report at page 554. This is what the court held in Holding 1. When a tribunal adjudicated upon a matter over which it had no jurisdiction, its decision was a nullity, and the party affected thereby was entitled ex debito justitiae to have it set aside. A person was therefore perfectly entitled to raise the question of jurisdiction for the first time in the Supreme Court. So like I've told you, if you enter the conditional appearance, you have the next 14 days to bring the application. And if you don't bring the application, you'll be deemed to have waived your right to object to the regularity of the writs. You'll be deemed to have waived your right to object to the service of the writs. The only one that you can waive, whether you bring the application within 14 days or not, is his jurisdiction. Because as we've been told in Amoasi III and Twintoh, as for jurisdiction, if a court assumes jurisdiction of a matter that it didn't have jurisdiction over, so the whole decision will become a nullity. Now, if we proceed further, let us look at Order 9, Rule 7 and Rule 8. So, for all that we've said so far, we are reading from what the text writers say. What you must note is what you're about to read now, and that the rules itself. What do the rules say about conditional appearance? So for all that we've said so far, the rules will now make it clearer to you. So all that we've said about conditional appearance, if you look at Order 9, Rule 7 of the CI 47, this is what it says. That the defendants may file a conditional appearance. So Order 9, Rule 7 gives you the right to file a conditional appearance. Now read the portions I'm going to highlight so that you don't get confused. A conditional appearance is to be treated for all purposes as an unconditional appearance, unless the defendant applies to the court within the time limited for the purpose for an order under Rule 8, and the court makes an order under that rule. It says it should be treated for all purposes as an unconditional appearance, unless you apply within the time prescribed under Rule 8. This is what I was saying. That if you are entering a conditional appearance, you have the right to do so. But under Rule 8, you will see that, look at Order 9, Rule 8. A defendant may at any time before filing an appearance, or if the defendant has filed a conditional appearance, within 14 days apply to the court. So this is where the rule is. So if you enter a conditional appearance, you have within 14 days after filing that appearance to apply to the court for an order to 1, set aside the writ or service of the writ. 2, declare that the writ has not been served on the defendant. Or 3, discharge any order that gives leave to serve the notice on the defendant out of the jurisdiction. So that is what Order 9 Rule 8 deals with. So Order 9 Rule 8 is what says that after entering the conditional appearance, you have within 14 days after filing that appearance to apply to the court for an order to A, set aside the writ or service of the writ. So this A has two. You are setting aside the service of the writ itself or the writ itself. So 2 in 1 in the Order 9 Rule 8A. You are either setting aside the writ itself or the service of the writ. Or you are declaring that the writ has not been served on the defendants. Or you are bringing the application to discharge any order that gives leave to serve the notice on the defendant out of the country. If you think the court ought not to have granted that order to serve you out of the jurisdiction, you can apply to the court for that order to be discharged. So these are grounds for entering conditional appearance. So all the grounds I mentioned under ex parte item, look at it. Ex parte item says that you can object to the writ itself, that's the one you see over here, or service of the writ, or declare that the writ has not been served on you, and ex parte item added jurisdiction. So all the things that's when ex parte item, you see them under Order 9 Rule 8. The only one you don't see under Order 9 Rule 8 is jurisdiction. So if you are asked to mention the grounds for entering conditional appearance, remember these things under Order 9 Rule 8 and then add ex parte item so that you can add the jurisdiction. The key points to note about conditional appearance. Conditional appearance would be treated as an unconditional appearance if after 14 days of filing the conditional appearance, the defendant fails to take a step required by Order 9 Rule 8. So within the next 14 days, what will you do? If you look at, you say that after entering the conditional appearance under Order 9 Rule 7(1)(a), the defendant would have to resort to the procedure provided under Order 9 Rule 8 to ventilate the defendant's grievance, to attack the regularity of the writs, to attack the service of the writs, or to attack the jurisdiction of the court. So after entering it, you have the next 14 days where you can now bring your application to strike out the whole writ of summons or to strike out the service of the writ of summons. The point is that you are saying that the writ has a problem. So if we look at conditional appearance, and then you have entered conditional appearance, you have the next 14 days, bring an application to strike out a writ. And if you don't bring it, then remember your conditional appearance would crystallize to become an unconditional appearance. So I'm saying that there's a problem with the writ. I don't want you to even go into the matter. So the effect or the purpose of the conditional appearance that is stops the case for the set 14 days. So for the 14 days, nothing can be done about the case because the moment you enter the conditional appearance, we are waiting for you now for the next 14 days to tell us why you entered the conditional appearance. So until we deal with that issue, nothing else will be dealt with about the case. So if you look at this case of Republic versus the High Courts, Denu ex parte Avadali IV, the case tells you that a conditional appearance, it halts or it stops the proceedings for the said 14 days so that it will pave way for the reason why you entered the conditional appearance to be gone into. This is what was said in ex parte Avadali. You need to know this case because if you are confronted with what is the purpose of a conditional appearance, ex parte Avadali will be your answer. Republic versus High Courts, Denu ex parte Avadali IV. Avadali Sports, Avadali, reported in 1993-1994, One Ghana Law Report at page 561. This is what Adade GSC said, and I quote. The note on this rule in the White Book says as follows. The term conditional appearance means an appearance in qualified terms, reserving to the defendant the right to apply to the court to set aside the writs or service thereof for an alleged informality or irregularity, which renders either the writ or service invalid or for lack of jurisdiction. There's no real distinction between conditional appearance and appearance under protest. The latter term is more usually applied to appearance by a person served as a partner but who denies that he's a partner. The term conditional appearance, the whole purpose of a conditional appearance is to stop the case in its tracks, stop it from being gone into at all on this occasion, for the reason that the court has no jurisdiction to hear it. Again, the whole purpose of the conditional appearance is that it stops the case in its tracks, it stops it from being gone into at all, and the reason is that the court has no jurisdiction to hear it. This is what we mean by a conditional appearance. This is the purpose of a conditional appearance, that I have entered my conditional appearance. The moment I enter it, the next 14 days, you don't go into the merits of the case. Wait for me, the defendants, to bring my application so that you know why I entered the conditional appearance. You will know whether I have a problem with the issuance of your writ, the service of your writ, or the jurisdiction of the courts. So that is the purpose of the conditional appearance. And so read Ex parte Abadali to know the purpose of a conditional appearance. Now, there's something interesting to note about Ex parte Abadali. The question that is it mandatory for a defendant who intends to object to the jurisdiction of the courts to always enter conditional appearance? And let me tell you why I'm asking this question. I'm asking this question because you remember in Ex parte IEP, we were told that jurisdiction is one of the grounds for entering conditional appearance. So I'm asking that if you fail to enter a conditional appearance, or if the court lacks jurisdiction, do you necessarily or mandatorily have to file a conditional appearance so that if you don't file it, it means that you can never object to the court's jurisdiction? See what Adade GSA had to say in the Ex parte Abadali IV. Republic versus High Court, Denu, Ex parte Abadali IV. This is what he says, and I quote. Quite apart from the general law that objections to jurisdiction may be taken at any time, there are at least two ways of presenting such a situation to the courts. A defendant may apply unconditionally, may appear unconditionally, and raise the issue of jurisdiction in his statement of defense as a defense. And at the appropriate time, ask the courts, if so advised, to take that issue and try it in limine. Or the defendant may also file a conditional appearance and move the court to set aside the writ of summons and statement of claim. So there are two options available to defendants here. Take a look critically. This Adade is saying that the defendant can either enter conditional appearance and apply to strike out the case, or he can actually enter an unconditional appearance and raise the issue of jurisdiction in his statement of defense. And I'm considering from Adade, he says, if he chooses the latter course, and by latter course he's referring to if he chooses entering conditional appearance, his reasons for contending that the court has no jurisdiction can only be stated in the affidavit accompanying the motion, since there will be no statement of defense at that stage. Now let me explain this. It means that if you, a defendant, you intend to object to the court's jurisdiction, you have two options. You can either appear and enter unconditional appearance. And remember, if you enter unconditional appearance, you have the next 14 days to file your defense. So you rather raise the issue of jurisdiction in your statement of defense. But if you enter a conditional appearance, remember, if you enter conditional appearance, you haven't filed a defense at all. So the grounds for saying that the whole action should be struck out on grounds of jurisdiction, you put those facts in your affidavit in support of the motion to strike out the whole action. So that is for the answer to that question. So if a defendant intends to object to the court's jurisdiction, the defendant who intends to object to the court's jurisdiction has two options. You can enter conditional appearance and bring your application, or you can enter unconditional appearance and raise the issue of jurisdiction in your statement of defense. Now, the next question you must resolve is this. In the event that a plaintiff issues a writ of summons, which is tainted with an irregularity in its issuance or service, and a defendant enters unconditional appearance, can such a defendant raise an objection based on the irregularity in the issuance or service of the writs? Let me explain this. Let's say the plaintiff has issued a writ, and then it turns out that the writ that has been issued, there is an irregularity in its issuance. Maybe some address was not stated, or there was a problem with how it was saved. Let's say the defendant, they didn't serve you personally, they served your brother. But you go ahead and you enter an unconditional appearance. Can you, after entering that unconditional appearance, raise an objection based on the irregularity? And I'm asking this question because remember, I have already mentioned the effect of an unconditional appearance. That you are submitting to the court's jurisdiction, that you are acknowledging the regularity of the writs, you are acknowledging the service of the writs. So if you enter an unconditional appearance, when, for example, you weren't served personally, your brother was rather served and he came to give it to you, when you were the one that ought to be saved, but you go ahead and enter an unconditional appearance, what is the effect of that? The answer to this is in the case of Kweku versus Mobile Ghana Limited in Holding 2. This is what the court said, and I quote, "An irregularity in the issue or service of a writ of summons, or an informality connected therewith, might be waived by the entry of an unconditional appearance. Consequently, having entered an unconditional appearance, followed by the statement of defense, the second defendant was deemed to have waived the irregularity arising from non-compliance with LN 140. So you have been told in this case of Kweku, Q-U-A-I-K-O versus Mobile Oil Ghana Limited, that if you enter the unconditional appearance, you'll be deemed to have waived your rights to object to the irregularity. That is the answer to that particular question. So the role as a lawyer is very crucial because you must determine when there's an irregularity so that you can enter a conditional appearance. Because if you don't enter the conditional appearance, it is possible you'll be deemed to have waived your right to challenge or raise any issue about that kind of irregularity. Then there's something we call late appearance, and this is under Order 9 Rule 6. Order 9 Rule 6 says that a defendant may not file appearance after judgment has been entered in the action, except with leave of the court. It means that if you, the defendant, judgment has already been entered against you, let's say they serve you with a writ, you didn't enter appearance, and they've gone ahead to take default judgment against you, please, before you enter appearance in that suit, you must seek the leave of the court. You can't enter as of rights. Because you are too late. Judgment has been obtained against you already. So if there's judgment against you, please, you cannot enter the appearance unless you seek leave of the courts. So, for example, we serve you with a writ. You have 8 days to enter appearance. You didn't enter the appearance. I've gone ahead to take default judgment. Then you now come and enter appearance after coming after, let's say, 2 months. No. Once judgment has been entered, you cannot enter appearance unless you come and seek the leave of the courts. But what if I serve you with a writ on 1st January, and as of 31st January, you want to enter appearance, but there's no judgment because you are out of time? Listen carefully. I serve with the writ on the 1st, so you have 8 days. So let us by maybe 9th, you should have entered appearance. But you've come in, let's say, February. But at the time you want to enter the appearance, I have not yet obtained judgment against you. Should you still seek leave of the courts? Because in this instance, there's no judgment against you, but you are still late. You are not coming within the 8 days. Writ was held on the 1st. Maximum time you had was to the 9th. Then you come on, let's say, February. You want to enter appearance, but there's no judgment yet against you. Must you seek leave of the court because you are out of time? Look at Order 9 Rule 6 Sub Rule 2. It states as follows, and I quote, except as provided in sub-rule 1. Nothing in these rules shall be construed as precluding a defendant from filing appearance after the time limited for appearance. But if the defendant does so, the defendant shall not, unless the court otherwise orders, be entitled to serve a defense or do anything later than if the defendant had appeared within that time. I'll read from the book titled Civil Procedure in Ghana, Civil Procedure, a Practical Approach by Kwame Tete, that will explain what the late appearance is. But before I read it, take a look at it critically. This Order 9 of Sesab 2 is creating the impression that so long as there is no judgment against you, you can still enter the appearance even though the 8 days may have passed. That is what the Order 9 of Sesab 2 says. That so long as the time has passed and there's no judgment against you, you can still go ahead and enter your appearance. This is what the rules say about entering appearance. A defendant served with a writ in Ghana. This is what Kwame Tete says. Who desires to enter appearance must do so within 8 days or such time as the court may specify. If served outside Ghana, the defendant must do so within the time specified in the order for service or such extension as the court may grant. Once judgment is entered, a defendant may not enter appearance without leave. Again, once judgment is entered, a defendant may not enter appearance without leave. It follows that a defendant may enter late appearance without leave of the court at any time before judgment. So you see, like I was saying, once there's no judgment, that one you can enter late appearance. Unless the court otherwise orders, a late appearance would not extend the time for filing a statement of defense or doing any other act required under the rules. The rule does not apply where the defendant seeks to set aside a judgment entered in default of appearance. Entry of appearance is not required for such an application. So what we need to know now is that once your time has passed, 8 days have passed, and you didn't enter appearance, if judgment has been obtained against you because of your defaults, that's one, according to Order 9 Rule 6 Sub 1, you must make sure that you seek the leave of the court before entering appearance. But if your 8 days have passed, but there's no judgment against you, you can go ahead and file the appearance without seeking the leave of the courts. The next lecture we will deal with will be default of appearance. But by way of recap, what we have done so far in this lecture is that we have dealt with appearance, which we have said can be a conditional appearance or it can be an unconditional appearance. We have dealt with the effects of an unconditional appearance. That unconditional appearance means that you are submitting to the court's jurisdiction, you are submitting to the regularity of the writs, you are submitting to the regularity of the service of the writs. Then we mentioned that appearance can be entered into personally or through a lawyer. Then we mentioned that to enter appearance through a lawyer, there are some exceptions. Remember, we mentioned that if you're a person with disability, that one, you can't enter appearance yourself because the rules require you to do everything to your next friend or guardian ad litem. We dealt with content of the appearance. Remember, I told you that whenever you draft the appearance, make sure that you have the certificates also down there. Take a look at the sample I showed to you and then you see it. Remember, I said appearance is not physical presence in courts. It is you filing that process that we looked at, either the conditional or the unconditional. Grounds for entering conditional appearance. Remember, we mentioned them. They are limited grounds and they are in ex parte aite. So if you combine ex parte aite with Order 9 Rule 7 and Order 9 Rule 8, you get the grounds for conditional appearance. You want to object to the issuance of the writs, service of the writs, or notice of the writs, or you want to object to the jurisdiction of the courts. Remember, if you enter conditional appearance, you have within 14 days to bring the application to strike out the writ or the service. If you don't bring the application within the right time, you begin to have the conditional appearance will now change to become an unconditional appearance, where it will now mean that time will now run for you to file your statements of defense. If there's a problem with the regularity of the writ or the service, and you enter on unconditional appearance, remember, it said that you be deemed to have waived the right to object, as we have seen in the case of Kweku and Mobile. Purpose of conditional appearance. You remember we look at Ex parte Abadali, the fourth, that the real purpose is that it stops the case in its tracks. It prevents nothing from being done apart from going into the reason why you entered the conditional appearance. That the whole purpose of a conditional appearance is to stop the case in its tracks. Then we went ahead to look at late appearance. That once judgment has been entered, you cannot enter appearance unless you seek the leave of the courts. So in our next lecture, we'll deal with default of appearance. Thank you.